Good morning. I'm Judge Tammy Long Hayward. This is the State Court of Clayton County, courtroom 304. I'm going to call the calendar in a moment. This is the criminal motions calendar. So for the cases on this calendar, individuals have filed criminal motions to be heard prior to trial. We'll go down the calendar to see what is going to be heard or what is going to be resolved differently today. First case on the calendar is Luis De Leon.
Good morning, Judge Ross Gordon. In that case, how are you?
I'm good, Mr. Gordon. How are you?
I'm doing well. This case is scheduled for a motion to suppress. We filed a preliminary motion to suppress that was not particularized. We just received the paper discovery about a week and a half ago, and due to conflicts, we have not been able to find a time that we can go and sign the paperwork for the video discovery.
Don't
So
do it electronically? Like they can't do an electronic
we
signature?
have we have to come to the office to sign a document allowing them to release it, and then once that's signed, then they send it electronically.
Mr. Brooks, I
The,
signed
yeah,
everything on my tablet.
I'm sorry, Senora.
I said I signed everything on my tablet.
Yes, ma'am. Well, it's a waiver of inspection of the video. So what ends up happening, what happened previously is that folks were saying that they didn't have an opportunity to watch the video. And so by being present, you have the opportunity to watch the video.
Okay,
And if you don't want to watch the video, obviously you can sign and we just send it to you electronically.
I get it.
Yeah, and I'm
But
not blaming the state for any of this. This was just the last week and a half since we got the paper discovery, we've had so many conflicts with court that we haven't had an opportunity that was open to send somebody down there to sign it. If we need a motion in this case, it would not be a motion to suppress, it would be an immunity motion. But I just don't know for certain until I've watched the video.
So are you withdrawing the motion to suppress? Because we hear immunity motions prior to trial.
Yeah,
Once
yeah,
the-
Judge. I mean,
Okay.
I've based on my review of the paper discovery, I don't think there's really anything to suppress. It
All
would
right.
just be an immunity hearing. But while I'm on the call, I would request just a brief pre-trial with Mr. Brooks, just to kind of see where we're at and see what we can resolve. I don't think we're going to be able to resolve it today, but just I want to take advantage of being here.
All right, so give me a minute to go through the calendar. Once we have that, we'll give the opportunity for attorneys to speak with the state.
Thank
Let's see
you,
what we
Judge.
can resolve. All right, the next case is Shanique Tashana Dunham. Dunham?
Good morning, Your Honor. Attorney Tortorello, Lister Holton Dennis on behalf of Ms. Dunham. Upon review of both the incident report and the video, I did not find that there was any violation of my client's constitutional rights. Therefore, we are withdrawing our motion to suppress, and notice was filed yesterday.
Okay, thank you. Tanisha Keandria, I'm sorry, did somebody else? Okay, Tanisha Keandria Goodman. This is Ms. Wright.
That's a case where Attorney Wright Merble Wright is a attorney of record, but it's my understanding she has a conflict. I also understand that this case had previously been on a calendar and was continued for the same reason. It's a motion to dismiss. I read
Yeah,
through.
I'm not real clear on the motion to dismiss on the
Yeah.
battery case. I
Yeah.
think we handled one previously filed by Mr. Sailors, and I was like, yeah, I'm not. Yeah.
And that was my challenge as well. So I was going to ask the court to dismiss the motion. However,
All
counsel.
right, the motion will be dismissed
Thank
for
you.
warrant of prosecution. This is the second time it's been brought. We don't.
Your Honor, I just wanted to note for the court,
Right.
try to interrupt.
Ms. Wright is here.
Oh, okay. All right.
All right, Ms. Wright. Okay, so we have motions to suppress, motions for immunity. What is a motion to dismiss?
Yes, Your Honor, if it pleases the court, my client, the alleged victim in this case has moved forward, and I think he is here today. He notified the clerk of court, as well as the solicitor's office, as well as he's been in contact with us, that there was no violence. He
Okay,
said
then that's,
there's no victim.
okay,
And
so,
he's here today to testify that this warrant should not have issued, because he is not going to testify that he was ever injured in any domestic violence occurred to him. with my client.
Mr. Brooks?
And this is file, Judge. It's very-
Hold on, Ms. Wright, hold on.
Your Honor, just looking at the incident report. According to the officer, he made certain statements that indicated that were the basis of the charge. The officer has been served. However, we didn't anticipate Ms. Wright to be here based on the conflict that was filed. The officer, I don't believe, is online, but we would put the officer up to substantiate or support the filing of the charges.
Your Honor, if it pleases the court, my conflict letter explicitly states that under Rule 17, the criminal matter takes precedence over the civil matter. As a matter of fact.
Okay, ma'am, I didn't see your conflict letter. I just saw that you had a conflict file.
Yes,
So
it has been stamped in, Your Honor, and it was received by the court in a timely fashion. So I never said that I was going to be unable to appear. I always.
all right, Mr. Brooks, do your best to get your guy on the line. We'll
Okay.
have a hearing is what Ms. Wright wants.
Okay.
All right.
Your Honor, may it please the court, how long are we going to be in the whole pattern for the officer to appear? Because he should have been noticed to be here. So we wanted to make a motion to dismiss for warrant of prosecution. We're raising
Dismiss
our
what?
motion now. If the state is not ready to go forth and they're
Well,
waiting to witness it.
Okay, so we honored your previous conflict, so I wouldn't go to that draconian step first. So what I'm gonna do is, I'm gonna let them reach out to their client and update me. We still have to get through the rest of the call of the calendar.
Yes, ma'am. I was going to say that the victim is here.
Okay, well, I get that. I get that he's here, but I can't just put up his testimony without the opportunity for the state to put up testimony in rebuttal. I can't just have a one-sided hearing. So a lot of times we have victims who are here when we can't move forward right away.
Thank you, Your Honor.
All right. So Ms. Wright, you know how this works. The prosecution, if they believe that there's probable cause to go forward with the prosecution, that's their decision. I can hear it, but generally this is in the nature of a probable cause hearing that should have been held in magistrate court. State court does not generally do probable cause hearing with the idea that you, at the end of the hearing, the case would be dismissed without it being within the purview of the prosecutor to do so.
Finally, Your Honor, we were not retained prior to,
I got you.
Probably.
I'm not blaming you. I'm just saying that what you're asking me for is in the nature of a probable cause hearing. That is generally done at the magistrate court level. I generally do not sit on hearings that require me to dismiss entire cases. I can sit on a plea and bar. I can sit on immunity, all of those things. But what you're asking is something that where I'm having to determine probable cause to actually bring the case. And as you know, the reason it's done at the magistrate court level is because once further investigation is done, then the state has the opportunity to bring it back at the trial level. So just being clear on where I'm sitting with this, okay? I'm willing to hear it. You filed it. I don't know that there's any, it's not something that's filed a lot, but
is this more akin to an immunity motion?
I know she said there was no crime. So it wouldn't be that nothing happened. So if nothing happened, it wouldn't be in the tenor of an immunity motion.
Okay.
All right. So Melinda Johnson, that case is closed. Manielle Kennerly, that's a plea and bar and an immunity motion, Mr. Morgan.
Yes, Your Honor. Good morning, Your Honor. The plea and bar, Judge, should be dispositive of the case, and there's really no need to have the immunity motion.
Okay.
Certainly today, I would anticipate that the plea and bar will be handled by argument only. I don't think it'll take very long. And I don't believe the alleged victim is here if we were to have an immunity motion.
I am.
Judge, we did not waive physical presence on the immunity motion.
Okay,
But once again, the plea and bar should be, if you grant it, it's certainly dispositive of the case. If you
actually are.
don't grant it, then we'd need the immunity motion. And just to let the court know, Judge, I'm number one out on Monday in state court of Henry County in front of Judge Lottie.
Is it an older case than mine?
It is
Okay.
not by much.
All right.
No, it is not an older case than yours. I'm sorry. It's a 2024 case. This is 2022.
Well,
I'll present the appropriate conflict level.
okay, but not sure what that means in as much as my case is older.
I understand you.
I'm not sure why Judge Lottie should get to have you before me, and since my case is older and we have trial at the same time. But you think on that.
You're
All
correct.
right.
You're correct, Your Honor.
I know. I've been doing this a while. Rodriguez Revelto Maddox. Rodriguez Revelto Maddox.
Yes.
All right. Was this motion withdrawn? Because I have 1,000 attorneys. Antonio Stanfield, Jonathan Overman, Emily Long, no relation. Harley Sitnick.
Yeah,
Your
yeah. It's my understanding that counsel may have filed something, Jonathan Overman, something related to an emergency conflict related to being a SAG, like some type of emergency hearing.
I
But
saw that. So he's a
nonetheless, it's
SAG
not particularized though.
in Henry County in juvenile court. Then he's got DeKalb County and then us. And the reason that DeKalb County was prioritized is because they start at 9 and we start at 10, but my case is older. All right, let's hold on for a second. Chase Nicholas Metz. This is Mr. Florio.
I think Attorney Florio is on trial in Judge Mason's courtroom.
Your Honor, he did send an email to Your Honor's chambers and CC'd the state in that he is presently in trial.
Okay.
You want to reset it, Judge?
Yeah. Anyone, if he's doing a special demurrer, set it before trial. I'm not gonna put this back on a motions calendar.
Okay.
All right. Yeah, it's a 2020 case, so it should be coming up pretty soon. Anyone here on Chase Nicholas Metz? This case is gonna be, the motion will be set before trial. So you're free to go at this time. If you are a witness for the solicitor's office, please take your direction from the solicitor's office about when and you need to be here. All right. Elton Gerard Murphy. Elton Gerard Murphy.
Morning, Judge. Mike Bixson from Mr. Murphy. He is online. I don't think we have any motions set for today, Judge. I've been speaking to the state.
Motion to modify bond.
Must have been an old one, Judge. Let me check here.
All right, so y'all are free to go at this time.
Okay, and Judge, if I could actually pre-try this prosecutor, I'd appreciate it if they have any availability.
All right, we'll see. All right,
Thank you, Judge.
Adrian Delafleur Nash. John Tucker's the attorney. Yeah, Mr. Murphy, just mute your device and hold on for a moment. Your attorney wants to speak with the state, okay?
Okay.
All right, just press mute for me. Thank you. All right, Adrian Delafleur Nash.
Yeah, I believe there's a bench warrant for Ms. Nash, and so is she present in the courtroom?
Well, that was the whole purpose of the motion, was to set aside the bench warrant, but I don't have her or
Attorney Tucker. We'll ask that the motion be dismissed, Your Honor.
Okay. The funny thing is that I think there's an attorney who works for the bar named Adrian Nash.
Yeah, she used to work in this office.
Oh, wow. Okay.
She was the deputy chief, actually.
Yeah, in the section that prosecutes bad attorneys.
Mm-hmm. Mm-hmm.
That's fine. Okay, yeah, I haven't heard anything from Mr. Tucker. I don't have a conflict. Has anybody received a conflict notice? It should have been filed. Ms. Wright, you have anything on Mr. Nash's case? If not, that is going to be dismissed for warrant of prosecution.
Are you on?
No, ma'am, we do not.
All right, so the motion will be dismissed. Anyone here on the Nash case, you're free to go at this time. All right, Malika Kamika Raphael.
Good morning, Your Honor. Angie Walton for Malika Raphael. Your Honor, we received video discovery last day. Upon reviewing it, we discovered that it was for the wrong defendant. Mr. Tipton provided us with the video discovery on yesterday, and I've watched a portion of it, and I'd like to have just a day or so to finish it. I anticipate I may be filing an immunity motion, and if so, I can get that filed by tomorrow, say noon.
So the concerns for Jackson Deno and a suppression hearing, we don't have those anymore.
No, Your Honor.
All right, so we'll withdraw those. You can file the immunity motion pre-trial.
Okay.
And just make sure you file it with the clerk's office at least a week prior to trial. And we have those in court on the first day of trial. We have our.
Your Honor, would you want me to do a formal withdrawal of those Jackson Dental motions and all that? I can.
You can. Thank you.
Not a problem.
All right. All right. Well, when your case comes up for trial, we'll see you then. I think you are. I think it says that that was the co-defendant. Oh, there was a co-defendant is on a bond forfeiture calendar, but Ms. Raphael does not have that.
Yes, ma'am.
All right. Thank you so much, Ms. Walton.
Okay.
Look forward to seeing you again.
Thank you.
All right. Derek Leon Smith Jr., Lister Holton Dennis.
Yes, Your Honor, the Attorney Tortorella on behalf of Mr. Smith. He is present in the Zoom call. We are not moving forward with the motion to suppress, and a notice was filed yesterday, Your Honor.
All right, so that will be dismissed. Withdrawn for the motion to suppress. Anyone here connected to the Smith case, Derek Smith case, you're free to go at this time. Any, like I said, any witnesses on any of these cases, please take your direction from the Solicitor General's office with respect to future appearance. Howard Staton, S-T-A-T-O-N, Howard Staton.
Good morning, Judge. It's my case, Cameron Slee with Scott Smith's office. I would like to pre-try that with the solicitor if we do get the chance before proceeding forward with motions. And I would object to the officer appearing via Zoom. We were not given any notice for a Zoom appearance for this particular witness.
Okay, well, does your notice say that it's a hybrid hearing, that you can appear in person or on Zoom?
I got to double check. I did not believe, but I do know that Superior Court Rule 9.2 requires 30 days notice in regards to the witnesses appearing via Zoom.
The notices go out well before 30 days. This has been on the calendar for a while.
I'll double check the notice.
All right, thank you. But I'm pretty sure the notice says it's a hybrid hearing. If you have any objections to them appearing by video, you might want to make those when you get the notice.
Understood, Judge. But I would like to pre-try this with, I believe
I would like that. What's your last name again for me, sir?
It's Salih, S-A.
Oh, you're Mr. Salih. I'm sorry, I just didn't hear, so it glitched and I didn't hear your last name. All right, so this is what I have. De Leon is withdrawn, Dunham is withdrawn, Goodman is going to be a dismissal hearing, Johnson is closed, Kennerly is going to be a hearing on motion, a plea and bar. Maddox is a motion to suppress, motion to dismiss, and Metz, that's continued. Murphy is withdrawn. Nash is a dismissal for warrant of prosecution. Raphael is withdrawn. Smith is withdrawn, and Staton is wanting to have a conference. This is a motion. So, Mr. Salih, did you want to go forward with the hearing also? I'm sorry, this was
it's a motion to suppress, Judge.
Yeah.
Yeah, I can say probably with absolute certainty that the officer won't be able to be here today, without like advance notice.
If you mean in person,
Yes, ma'am, because we got GBI witnesses that's necessary as well.
they've been subpoenaed.
They all have been subpoenaed, is my understanding. Natalie Hips, there's an officer Baster, but it was contemplated that it would be online. So
Okay.
if it's
All right, well, let's y'all conference first. So I'm gonna set up the breakout room. We're
Judge,
gonna
if
do a
I may.
conference. I'm sorry.
I apologize, Judge. I just want to let the court know for Mr. Murphy, I did find that motion to modify the bond. I apologize. It's been a year ago since I had filed it. But we are ready to go forward on that, but I still would like to talk to the state if that's okay with the court.
Okay.
And
Yeah,
Your
that's fine.
Here is present here.
I'm sorry.
I'm Sergeant Bastier and I am present. I heard
Okay. Yeah, we were checking on the individuals for this last hearing. Thank you, sir. Just hold on for me for a second. Let me go ahead and set up the conferences so y'all can quickly run through this and see if any of these outstanding matters can be resolved before we do the hearing to dismiss and the hearing for the plea part. We have one solicitor, ladies and gentlemen, and so that makes it a little bit difficult because you know, in the past we've had two. But what I'm going to ask you to do is just
yeah, Your Honor, I'll be able to handle matters as well, Your Honor.
Oh, okay. All right. I'm sorry, Mr. Brooks. So, Mr. Brooks, can I do this? Can I put the people in the conference to talk to you and then have Mr. Tipton handle the plea and bar?
I was going to handle the plea and bar.
Okay, and then I'll put him in to talk to Mr. Tipton. I'm sorry,
Okay.
Mr. Tipton. Sorry, Mr. Brooks.
No worries.
So, Mr. Tipton, I'm going to set up the breakout room first with Mr. Gordon. And once you all come out, then I'll go on to the next person and then the next person. All right, so this works better. Thank you.
In regards to my pre-trial, I
Yes.
spoke to Mr. Tipton ahead of time on the phone, and
Okay.
I actually need to speak to Mr. Brooks on this case.
Okay, so Mr. Tipton, let me take you to the next person. That will be Mr. Dixon. And then once you speak with Mr. Dixon, then while you're doing that, we can go ahead and get get the plea and bar done.
Yes, Your Honor. Thank you.
Mr.
Judge, we're here in person. Can I just walk down to the solicitor's office and pre-try there? So
that's up to them.
Your Honor, walk down. My apologies, Your Honor. I can walk down.
Okay, so he's gonna, as soon as he finishes speaking to Mr. Dixon, Mr. Sally, he's gonna come down and speak with you. Okay, no problem. Mr. Dixon, I'm sorry, Mr. Bixson. I keep calling you by the wrong name. So, Mr. Bixson, you're gonna be in breakout room number 3 with Mr. Tipton. All right, now, Mr. Morgan.
Yeah, can you
this
hear
is
me okay from here? Do I need to step up closer?
Step up a little bit closer for me, sir. Okay. Just because I can hear you, but I don't want to strain our very kind court reporter who, you know, I'm very fond of, and I don't want her to leave me because I can't make things work well for her.
I understand, Judge. Can you hear me better now?
I hear you great. Thank you so much. All right. So this is the matter of the state of Georgia versus right page, sorry. State of Georgia versus Manuel Kennerly, 2022 CR 01195. This is on Mr. Kennerly is represented by attorney Byron Morgan, who is in court with him today. And this is a plea in bar. There's also been an immunity motion filed, but we're going to take the plea in bar first. Battery, family violence, count 1, battery, count 2, simple battery, count 3, simple battery, family violence, count 3, and simple battery, count 4. Arguing on behalf of the state will be the Solicitor General, Mr. Charles Brooks. All right, Mr. Morgan, Mr. Brooks, are you all ready?
Thank you, Your Honor. Judge, the original accusation on this case was filed in September of 2021. the original accusation accused the defendant of various crimes, but the alleged victim was said offender. And that's the exact phrase that was in there, said offender. Now, apparently, and had that remained, Judge, we would have just tried the case and they wouldn't have been able to convict, because that doesn't describe a crime at all, because there's no named victim. But
I'm sorry. Okay, go back. It says the original accusation says said offender, where it should say victim.
Yes, Your Honor.
Okay. All right, go ahead. I'm sorry.
And they apparently caught this mistake and amended the accusation, but it was done long after the statute of limitations had run. And they changed the alleged victim to Tanya Soden.
What date was the amendment?
I'm sorry?
What date was the accusation amended?
August 13th, 2025 here.
All right, go ahead, sir.
And Judge, when they did this, now the law allows them to amend an accusation to create a typo. This is not a typo. This is changing from a missing material element of the crime to substituting now a material element of the crime. So what we've gone from, Judge, is no crime to a crime. And Judge, I just state to you that that's clearly not what the law allows. I cited in my brief the case of Thomas versus the state from 1998. This is actually a case out of the creation of the Fayette County State Court. And in that case, all they did was amend a date. Well, we all know that a date is not a material element of a crime. And all they did was amend the date, and the Court of Appeals said that it was not error. In fact, they said the solicitor merely amended it to correct an error, a typographical error, as was his right. And if this were a typographical error, I would tell you that, in other words, if they misspelled her name, I would tell you that that's perfectly allowable. But that's not what happened here, Judge. They changed it from no crime to a crime. And the Thomas case states it's long been the law that where the date alleged in the indictment or accusation is not a material element of the offense, the state may prove the offenses of any date within the statute of limitations. Well, that is not remotely similar to what's happening here. So, Judge, they just don't have the legal authority to do this. And the statute of limitations is run, and I contend, the defense contends, that prosecution is therefore barred. Thank you.
Okay. Mr. Brooks.
Your Honor, I think counsel was absolutely accurate in that the previous accusation was fatally flawed. And as such, his client is entitled to a perfect accusation to be tried upon. 17771F provides that prior to trial, the prosecuting attorney may amend the accusation, summons, or any citation to allege or to change the allegations regarding any offense arising out of the same conduct of the defendant which gave rise to any offense alleged or attempted to be alleged in the original accusation, summons, or citation. The question before the court is whether or not the amended accusation that was amended beyond the statute of limitation broadens or substantially amends the original charge. It's the state's position that this fatally flawed accusation was amended to make the accusation, one, sufficient to be tried upon, but also to make the accusation more succinct to allow counsel to properly defend his client. The state would offer to the court Barghi, that's BARGHI versus state. That's 334 Georgia Act 409. That's a 2015 case similar to this case. However, it's a DUI case where the state amended the accusation beyond the statute of limitations. It was upheld basically because what the court found was that by amending the accusation, it made it more succinct. And as the language of the prior accusation was deficient, it would be the state's position that the amendment of this accusation makes this accusation more succinct to be for there actually to be a trial.
All right, let me ask a couple of questions. So how many counts were on the original affidavit? I mean, accusation?
4.
Okay, and did each of those 4 counts have, instead of victim's name, said offender?
It's count 1 says said offender, count 2 says said offender, count 3 says said offender, and count 4 says said offender.
So in no part of the accusations as filed originally prior to the statute of limitations running, was there ever a named victim?
No, ma'am.
Okay. So when it says in OCGA 17-7-71, it what was it? Sorry. C, where it says every accusation which states the offense in terms and language of the law, or so plainly that the nature of the offense charged may be easily understood by the jury, shall be deemed sufficiently technical and correct. So at the time that the accusation was originally made, did it meet the standard in subsection C?
It did not.
Okay. And so well after the statute of limitations has run, now the accusation is being amended such that it now meets the standard in section C.
Yes. So the previous accusation filed in 2022, basically the way it reads as if the offense was against the defendant.
Right. Okay. So does the issue with an accusation is whether the accusation is sufficiently is it drawn sufficiently to put the person who is accused of an offense on notice of what elements of the offense he's accused of having committed, when date, time, victim, if it is a crime that has a victim who should be named, and then what actions were taken towards that victim that would constitute a crime. But if at the time that it was done, what was alleged wasn't a crime,
Well,
but to amend it after the statute of limitations to now say you're charged with a crime and this is the crime that you're charged with.
well, if that were the case, then that means that every fatally flawed accusation that's beyond the statute of limitations could not be amended. We have to try a fatally flawed accusation. Like if this were going to trial and counsel purports that he would take this to trial, we could not have a trial. But the law also states that the defendant is entitled to a perfect accusation. The way the original accusation reads, it reads, for that the accused on the 4th day of September 2021 in Clayton County, Georgia, did intentionally cause visible bodily harm to said offender by striking her in the face. Now it says her in the face, indicating that it was a female as opposed to the male defendant. But it says said offender by striking her in the face with a shotgun, causing her 2 front teeth to chip. The accused and said person weren't living in the same household at the same time of said offense. That's count 1. Count 2 is similar. Count 3 and 4 are basically the same language.
Well, the issue that I have is whether the defendant in this case was sufficiently informed of what he was accused of prior to, I mean, you amended it to pass the statute of limitations, but he spent all of that time until the statute of limitations run, not actually being charged with a crime. Once the statute of limitations ran is when he actually was charged with a crime. It wasn't something where there was a mistake in the year, you put the wrong year on there, or the mistake in the spelling of a name. It was that there was no actual crime. Hold on just one second. I'll be right back. All right, I'm sorry. Okay, so the up until the statute of limitations ran, Mr. Kennerly wasn't charged with anything. He was like, so we could not have proceeded to trial on the accusation that existed. And I get the argument that he's entitled to an accusation that is not flawed, but to amend an accusation to make a crime where no crime was accused prior to the statute of limitations running, what is the whole point of a statute of limitations?
I think, well, the obvious point for a statute of limitations is finality, right? But I think the question before the court is I guess what constitutes a typographical error?
Typographical error to me would be you mess up a letter or two, or you put in a Q for the middle name, Q initial for the middle initial, and it's K. Not a whole name where prior to this, the first name is Doris and the last name is Jones. When we come to court or after the accusation is amended, it's now Doris K. Jones or Doris Smith. But at least he knows he's accused of hitting Doris. In this case, he went all the way through the statute of limitations, not knowing who an essential element of the crime is. If there's a victim in the crime, that person is to be named so that you have certainty as to which element of the crime you have to address. If there's 5 people living in the house and he hit Doris, but you never named Doris, and then the statute of limitations runs, well, he's never been put on notice of what he needs to defend against. And that's the whole point of the accusation. And if you go through the statute of limitations with what you say, finality, he has a right to expect that if I get through these 2 years and I have not been charged and I have not been properly charged such that it meets all the elements of the crime, after the 2 years runs, I should have some sense of security that they're not going to continue to prosecute me for something because the law set a time limit. Mr. Morgan?
Very briefly, Judge, I just want to address one thing. I think the court has covered everything else. Mr. Brooks' contention that it made this more succinct. No. He substituted 2 words for 2 words. Tanya Soden for said offender. It's exactly as succinct as it was before. Thank you.
Yeah, I think that the purpose of the statute of limitations is to give certainty and finality to a criminal prosecution. If you have a 2-year time span in which to put this person on notice that they are accused of this crime under these elements, then I get that. But I get that they need an accusation without mistakes, but a mistake for me means a misspelling, even a misnomer. If the person is, like I said, if their maiden name is Smith, but they've been called Jones, but the first name is correct, that's a closer call. But to have somebody accused of aggressing or being violent against themselves, said offender, and then to now have them, after the statute of limitations has run, told that, oh, well, this is actually the victim that that was the essential element of this crime. I think that when we start getting into now giving essential elements of the crime after the statute of limitations has run, I think then that becomes violative of the purpose of what a statute of limitations is for. So in this case, I'm inclined to grant the plea and bar.
Thank you, Your Honor.
All right. Mr. Morgan, I need an order.
Do I need to prepare an order for the court?
Yes, you do.
Thank you, Your Honor. I'll give it to you today. Thank you.
All right, thank you. All right, so the next case is the dismissal case with Ms. Wright.
Yes, sir.
All right, this is the state of Georgia versus Tanisha Keandria Goodman. Yes.
Before you begin,
yes.
May I sound for the officer? I don't know that he made it on.
You may.
That would be Officer McGriff. Officer McGriff. Investigator Pugh, are you on? Investigator Pugh, are you on?
Good morning, Solicitor General. I'm standing in for him. He walked to the court.
Okay. The last communication I heard from Investigator Pugh was that the officer was expected to be on in about 10 minutes. I don't know if he was having technical issues or if he's on a call, but I don't know that the officer is presently on. Officer McGriff.
Officer McGriff, I could double up and get right back to you. Step out and make a phone call.
Thank you. James McGriff.
I got 2 pages of people on the calendar, so I don't see a McGriff, but I do see some, ladies and gentlemen, while I'm looking at this. So for ease of going through this calendar, because it's on video, it helps me if you put your first and last name on the screen. I see Google Pixel 9, Nokia X100, iPhone, Elton, just Elton, Clayton users IP. It helps if you put the first and last name on there, because if you're unable through some technical glitch to unmute and let me know that you are here, then I have the ability to look on the screen and say, oh, I see so-and-so, so I'm going to give them credit for being here until I can speak with them. And so that is the issue. Give me a few minutes, Mr. Gordon. You said you needed to speak with Mr. Brooks.
Yes, Judge, it'll probably take
All
2
right. Ms. Wright, just give me a few minutes. If the officer said he's coming on, I give room for trying to slide onto video, but we should be ready in a few minutes. Okay, Mr. Gordon, I'm going to put you in the breakout room with Mr. Brooks. And then I'm going to wait. Mr. Tipton, do you have an announcement? Do you and Mr. Bixon have an announcement?
Your Honor, I'm going to need to speak to my victim in that case. That will be Mr. One moment, Your Honor. Eldington Murphy, Mr. Eldington Murphy. And I'll need to be placed in a breakout room with Mr. Murphy and
Ms. Hemphill?
Yes, Your Honor.
All right. I see an Elton, E-L-T-O-N Murphy, but I see two of them. So there's two Elton Murphys on the screen.
Judge, I believe it's a father and son. They both have the same name.
Okay, can the father unmute and show me your video? Elton Murphy Sr.
And Your Honor, our victim is the son in this case.
Oh, Elton Murphy Jr. Elton Murphy Jr.
Judge, I heard my client, Mr. Murphy, the senior, I responded earlier, I believe, and I see him on
That doesn't help me, Mr. Bixon. When I'm looking at the screen and nobody's responding, nothing lights up. So all I have is just two Elton Murphys. I need to speak with Elton Murphy Jr.
Hello, can you hear me?
Are you Junior?
Yes, ma'am.
All right, let me rename you because this is hard to figure out without doing that. Hold on a second. All right, Mr. Elton Murphy Jr., I'm going to put you in a breakout room with Ms. Hemphill and Mr. Tipton. All right, so Mr. Tipton, I'm going to put you in breakout room number 1. Mr. Elton Murphy Jr., breakout room number 1, and Ms. Hemphill, breakout room number 1.
Hello?
Yes. Are you Mr. Elton Murphy? Okay, so sir, just mute your device. We'll be back to give you some information in a moment, okay? All right. Mr. Tipton is in the breakout room. We don't have an announcement on Mr. Bixon's case yet. Mr. Brooks and Mr. Gordon are in a breakout room. And as soon as they come back and we get confirmation, we'll move forward on the hearing in the Johnson case. Nope, sorry, in the Goodman.
Your Honor, may I be placed in a breakout room with Mr. Bixon one more time?
I'm sorry, Mr. Tipton, what did you ask?
Your Honor, may I be placed in a breakout room with Mr. Vixen once more?
Okay.
And Judge, I've spoken to Mr. Brooks. May I be excused? We're not going forward with motions today, and we're going to work on resolving the case in the near future.
Yes, sir, you may. Thank you. All right.
Thank you. Have a wonderful day.
You too. So, Mr. Vixen, you should already be in a breakout room or have the ability to go back into one. Hold on a second.
I'm still waiting for that little notice, Judge.
In fact, I'll put you in breakout room number 2, Mr. Tipton in breakout room number 2.
Thank you.
Officer McGriff?
Yes.
Okay. Officer McGriff, you can hear me?
Yes.
All right. Is your video functional? Okay. All right. Your Honor, at your pleasure.
All right, let's go. Miss Wright, come on up for me.
Yes, Your Honor, I'm at the, when we go up to the podium, I'm now seated.
One second. You can come a little bit closer because the podium, it's hard for our court reporter to take down. We're gonna figure out this tech fully at some point, but at this point, it works as good as can get. Okay, so the state's ready. Ms. Wright is ready. This is the case 2024 CR 04064 for Tanisha Keandria Goodman. This is Ms. Wright. Ms. Goodman is right.
Yes, Your Honor.
Okay, is she present in court or by video?
My client is here and the alleged victim is here as well, in person.
Okay, all right, and then the state is ready, state's witnesses are here. So this is a matter of the motion to dismiss filed by Attorney Wright on behalf of Ms. Tanisha Keandria Goodman. On behalf of the state is Mr. Charles Brooks. On behalf of Ms. Goodman is Ms. Wright arguing the motion, and Ms. Wright may begin.
Your Honor, if it pleases the court, we'd like to start our examination off with the office of Mr. McGriff.
All right.
The sworn officer, I'd like to give you an oath. You swear or affirm that the testimony you're about to give in the criminal matter of State versus Tanisha Q. Goodman will be the truth and nothing but the truth, so help you God.
You got to unmute, Mr. Officer McGriff.
Ma'am.
All right, so you're saying yes to the oath, is that correct?
Yes.
All right, all right.
Officer McGriff, on or about February 10th, I'm sorry, February 11th, 2024, did you have an occasion to go to the home of Miss Tanisha Goodman located in Clayton County at the address of 591 Osborne Court, Riverdale, Georgia?
Yes.
And why were you there?
It was for a family violence offense.
Okay, you weren't there for a family violence offense?
Yes, ma'am.
When you arrived, approximately what time was that?
Unknown.
That was, I don't know.
Yes, ma'am. If you give me a second, I can, if the court allows, I can cross reference. I do have the case pulled up. I wasn't notified of what the case was, but I now have it. So if you can give me a second, I can look at it and confirm.
All right, Ms. Wright, it sounds like he's asking to refresh his recollection. You want to instruct him on that?
Yes. According to your application for your warrant, you stated to a magistrate court judge in Clayton County that you arrived at approximately.
No, Ms. Wright, I meant that Officer McGriff, you're allowed to refresh your recollection, but you cannot testify from the document that you used to refresh your recollection. If you go ahead and review that document, and then when you're ready to continue your testimony, just indicate that to the court, okay?
Yes.
All right, thank you.
Time frame was at 11:53 hours.
Were you accompanied by any other officer?
I'm pretty sure I was. If it was a domestic, we're typically going 2 officers or 3 or more.
Do you know the names of the other officers who accompanied you?
No,
Is it in your report?
I don't know.
You didn't put those officers' names in your report?
If they played a vital role with some assistance, they would most likely be added to the report.
Upon your arrival at the residence, what do you estimate your time from getting a dispatch there to your arrival? What is your estimate in your arrival?
I don't want to be inaccurate. I don't know.
Upon your arrival to 591 Osborne Court, what did you do?
Spoke to the parties that was involved with. Who was the first initial contact that I made? Unknown.
Who are the parties that you spoke to?
Asking who were the parties I spoke to?
Yes, sir.
Again, it's in my report. So if I can see who it was, the first or the 2 contacts that was made, I can most likely let you know, but not off the top of my head.
Okay, I'll wait till you review your document.
I spoke to a Cordario Clayton and a Tanisha Goodman.
And who, in your opinion, was the victim of a crime?
Mr. Clayton.
And what was the crime?
Battery, family violence.
So he arrived, when you arrived, he was there. Did he make a statement to you?
Both parties that I mentioned did.
Did Mr. Cordario Clayton inform you that he had been injured?
If I'm not mistaken, yes.
Did he tell you what the nature of his injuries were?
Pretty sure it's in the report.
Did you tell for the court what the nature of the injuries were?
Yeah, can I look at the report?
So, Officer McGriff, if you need to refresh your recollection to answer a question, just say that. I just need to look to refresh my recollection, and I'll and then when you do that, just you can answer after that.
Absolutely.
Mm-hmm.
Okay.
Yes, sir. The question was, what injuries did you observe?
Mr. Clayton displayed a visible red bruise on the right, a visible bruise on the right side of the hip.
Right side of the head,
Hip.
on his HIP.
HIP.
Now, did you have an opportunity to see it? Did you take any pictures?
I'm pretty sure I did see it with it being a battery charge, and we have to collect photos of the incident to upload to the report to support the battery charge.
Okay. So were you also wearing a vest that could record while you were there?
Yes, it's mandatory policy to have our carrier and our body camera activated whenever we're dealing with a civilian.
So there was a body camera available?
Yes.
Was it recording at the time, or do you know?
Yes.
Yes, it was recording?
Yes, it was recording.
Now, you had the occasion to speak to both of them. Did Miss Tanisha Goodman tell you that she had struck him?
She initially stated that she struck him in the face when she went to answer the front door for him, and he tried to walk inside. She tried to close the door, and she said with him trying to come in, she closed the door and the door hit him in the face, which is another injury to the face that he had.
Did you observe any bruises to his face?
Off the top of my head, I can't recall, but I think it was possibly to the lip.
Okay, did you have an opportunity there to make an arrest?
Yes.
Both parties were present when you arrived. You observed that there had been injuries, and you stated that the victim told you he was injured by Miss Goodman?
Yes.
And what is the victim's name for the record?
Last name, Mr. Clayton.
So why didn't you place Miss Goodman under arrest while you were there?
I'm sorry, you're asking who the victim is, correct?
Yes, sir.
The victim is Mr. Goodman, or the gentleman who was involved, and the female was a suspect. She was placed under arrest.
Was she placed under arrest on the spot? That's my question. Did you take her into custody at the same time you arrived?
I don't recall. If I can refresh, please.
You may.
All right. So if I'm not mistaken, the question, could you repeat it, please?
Did you take Ms. Goodman into custody at the same time that you arrived on the scene?
No, ma'am.
Why not?
Because at that time, during my investigation, I assumed that I possibly had conflicting stories, which is why I had to call my lieutenant to get clarification on it. And once I contacted my lieutenant, he informed me that with this being 1913 family violence within the state of Georgia and or within Clayton County's police department policy, an arrest must be made if there is any form of probable cause to make an arrest. With that, at that time, I didn't see probable cause, which is why I had to obtain warrants afterwards.
So, and what do you define as probable cause? The injury was not probable cause?
Anything that supports under 1913 family violence. It could be visible injuries, it could be damaged property, it could be stolen items, anything of that nature.
So you stated that Mr. Cordero informed you that he had been injured. That was not enough, and that you also had seen the injury on the hip, the right side of his hip. That was not sufficient information or evidence for you to take out to place her into custody without a warrant.
You said without a warrant, that would have.
Yes, a warrantless arrest.
Yes, ma'am.
That's my question. Why did you make a warrantless arrest? You were on the spot, on the scene. You stated your camcorder captured injuries to the alleged victim and that he had given you a statement that he had been injured by Ms. Goodman. And they were both present when you arrived.
So an arrest probably wasn't made because if I'm looking at this, with me looking at the report correctly, this was almost 2 years ago since I've been on the road. So I don't know what the thought process was back then, which is why I'm giving accurate answers as of right now. Due to me not making an arrest on scene, an arrest was still valid to get criminal warrants, which is why I obtained warrants after the arrest.
You swore out a warrant the following day, is that correct?
I don't recall, but I'm pretty sure.
Did your commander or your hierarchy officer instruct you to arrest Ms. Goodman? Yes or no?
My lieutenant informed me to obtain criminal warrants for the offender. Yes.
And is that standard operating procedure? If you have seen evidence of a crime and you're on the scene, the alleged victim is on the scene and has told you that the victim is injured, is that standard operating procedure for you to leave the victim as well as the so-called offender and not make an arrest on that date?
No, it's not normal practice, but as police officers, we do tend to every now and then make a mistake. And at that time, I was a new officer, which is why I made sure to backtrack and get the criminal warrants as I was instructed to.
So you're admitting that you made a mistake?
For not for not obtaining warrants or for not making an arrest?
No, you just said you were a new officer and you had made a mistake by not placing the alleged offender under arrest.
Yeah, which is why I called my lieutenant. I called my lieutenant at that time to get clarification on what was needed to be done, which is why it was clarified that criminal warrants needed to be obtained immediately.
And who is your lieutenant that you call?
At that time, he was Lieutenant Gailey, but he's now Captain Gailey.
D-A-I-L-E-Y?
G. George, A-I-L-E-Y.
And he's now, what's the rank now?
Captain.
Now, this happened on or about the 11th of February, 2024. How long did it take you to take out the warrant?
Maybe 20 minutes, maybe. I don't know.
Do you have a copy of the warrant before you?
No, but I'm pretty sure I can. Actually, I cannot pull it up because we have a new system that we're using, which is why I won't be able to get to it because this report is so old.
So you don't know what you put in your warrant. You have no firsthand knowledge of what you swore to with a magistrate court judge in Clayton County.
I'm pretty sure if it was towards a magistrate judge in Clayton County, it would have stated that there was visible injuries towards the victim, which fell on 1913 family violence due to both parties admitting to being on and off in a relationship for 5 years and or living together at that time.
Is that what you charged there with? What
Yeah,
did you,
battery.
what did you charge Miss Goodman with? Are you
Battery, family violence.
okay? And that was because of the bruises to his hip. When I
Yes.
say he, the victim.
Yes.
Okay. Did you also have the opportunity to create a incident report?
A estimate report.
Incident,
Incident. Yes.
okay. Are you familiar with your report that you created?
That's the one that I'm using to do a refresher. Yes.
Okay, so if you you have that before you now, are you aware of the fact that it states in your incident report that you observed no damage to the front door? You just testified that the front door was being used to injure the alleged victim, injuring his right hip, right side of his hip. So are you aware of the fact that you made an observation that there was absolutely no damage to the front door?
If it's stated in my report that there was no damages, I'm pretty sure there were no damages, because if that was the case, it would have been criminal trespass, family violence at that point if it was $500 less, or it would have been criminal damage, which is 501 or more. But if there was no damages to the front door, there's no need to put it on the report if there wasn't, which is why it was battery, because the door was used to create a visible injury on the victim.
Now, are you also aware of the fact that in your incident report that you created, that you state that the alleged victim told you that Miss Goodman had struck him on his lip?
Yes.
Why didn't you put that in your warrant?
Because it still falls as a visible bruise that took place.
That's not my question. You have firsthand information from the alleged victim that he had been struck in his lip as well as on his right side, which you said you observed, but you failed to place that in the warrant.
Objection, Your Honor.
I'm asking a direct question, Judge. What's the nature of the objection?
I can't hear you, Your Honor.
What is the nature of your objection?
Your Honor.
Ms. Wright, I don't know what the objection is, so you've got to stop.
Hmm.
All right. Mr. Brooks, what's the objection?
The officer previously stated that he didn't have the ability to observe the warrant, to review the warrant.
Okay.
And his
He's asking
testimony
for speculation. What's the objection?
Well, the question was, why didn't you put that in your warrant? But the officer cannot answer that question. He doesn't have the frame of knowledge to answer the question because he hasn't had the opportunity to review his warrant. Because apparently, I think his prior testimony was that he couldn't remember what he put in the warrant.
I got it. So he's already stated that he doesn't have the warrant in front of him. So calls for speculation. Sustained.
Mr. Officer McGriff, when did you actually take the offender, Ms. Goodman, into custody? When was you taken into custody?
You're asking when did I take Mrs. Goodman into custody?
Yes, sir.
I don't recall. I'm pretty sure I don't remember if I took her in custody or not. I do remember obtaining warrants, but I don't remember if I was the officer who put the initial cuffs on her, placing her in custody. Now,
Let me ask you this. Are you familiar that under Georgia law, OCGA 17-420, you could have made a warrantless arrest on the spot if you deemed it to be a domestic violence case?
Yes.
So why didn't you?
As I stated previously, that I was a newer officer, and at that time during my investigation, there was an error that was made, which is why I got in contact with my Lieutenant Gailey, who's now Captain Gailey, who gave me the authorization to get criminal warrants due to me explaining everything to him.
Are you aware of the fact that the alleged victim, who is here in court today, has memorialized, has written a statement, had it notarized, and entered it into the clerk's office, giving the Solicitor General notice of the fact that everything you just testified to is a lie?
Objection, relevance.
That
Don't answer.
What you're asking him is, does he know there's a piece of paper in the clerk's office?
Are you aware, let me rephrase. My question to you, Officer McGriff, is, are you aware of the fact that the alleged victim has written a statement or is in the courtroom today to testify that he was never injured by the offender, Miss Goodman?
No,
You were not made aware of that.
no,
He never told you that he had not been injured?
no. During, if this is during the actual incident, at the time of the incident, if I'm informed that there was a injury in which at the time was to the hip and lip, that was the only injuries that I know of. But once I do my initial report or once I'm done with that particular call, there is no follow-ups. There is no conversations afterwards. It's work the call and you go to the next. So I'm not aware of anything that took place after the date of this report.
So it's your opinion today, as you testify, that the warrant that you swore out gives Miss Goodman sufficient legal notice of the charge that she has been, that has been made against her?
I'm so sorry. Could you repeat that?
Objection. That's a legal question.
Sustained.
Your Honor, I have no further for this one, this witness.
Oh, all right, Mr. Brooks, do you have questions for this officer?
I do.
Go ahead.
Officer McGriff, I remind you, you're still under oath. You testified previously that you were equipped with a body worn camera on the day of the incident. Is that correct?
Yes, sir.
And the incident was February the 11th, 2024. Is that accurate?
Yes, sir.
And how do those body worn cameras work?
So initially what takes place is when we're in our patrol vehicle and we're responding to a particular call, it's either activated before we get out the vehicle or before we knock on the door or make contact with the complainant or the caller at the time. So our body camera is audio, visually recording, and anything that is also stated is going to be collected on the body camera versus memory.
And you mentioned that is activated through the car, or are you physically activating it? How does it activate?
Physically activated. Some body cameras do activate if you initiate your license sirens, but it's physically activated majority of the times by officers.
Okay. And on that day, you were equipped with the camera, and was it working properly to your knowledge?
Yes, sir.
Do you know where the footage is loaded once it's recorded?
The initial location, no, but I'm pretty sure Clayton County Police Department has a database that they hold their video recordings.
Is it a cloud database?
Yes, sir.
And if I showed you a sample of the body worn camera that you had on that day, would you be able to identify it?
I'm pretty sure, yes.
Okay. Attorney Tiffany, if you could assist me in sharing screens.
Yes, Mr. Brooks.
Much appreciated. Before you show anything for the record, this is for identification. This will be state one. Attorney Tiffany, if you could go back to not at 1 minute not at 1 minute 18 seconds, but go back to the very beginning. Okay. Just by saying this very first shot of your body worn camera, does this look familiar, or does it refresh any recollection as relates to the incident location?
Yes, very familiar.
Attorney Tiffany, if you would, the entirety of this video is 24 minutes and 44 seconds. Attorney Tiffany, if you would go to the middle of the video, like 12 minutes. Do not play it though. Stop it. Okay.
This video proved I didn't do this. But yeah, I'm still in your fucking face. Can I leave, please? Thank you. Bye.
Oh, sorry.
Bye. Mind the rest. Bye. Bye.
Pause it. Is that the video playing?
That's not the video, I don't think.
I,
Unless it started to immediately try. Unless it started to immediately play, but I don't think it played.
Officer McGriff, does the individual in the picture look familiar to you?
Yes.
Who's the individual in the picture?
That is Mr. Clayton.
Okay. If you would, Attorney Tiffany, go to the end of the video. Officer McGriff, does this area or scene look familiar to you?
Yes.
What is this area or scene?
So at this point, I am, from where I'm looking, the house is to my right at this point.
Okay. Now, at this time, the state will offer into evidence what's to be marked as State's Exhibit 1, the officer's body worn camera.
I'm sorry, was that for me?
No, it's for the court.
Miss Wright, any objection?
Yes, I am. I'm gonna object, and let me state my form of my objection, Your Honor. There's absolutely no notice that there's a video recorder. Further, the officer has testified that there were accompanying police officers with him, which he said is the norm. Anytime there's a domestic violence a report, and they always go out with more than one person. I do not see any evidence of there being but one vehicle. That vehicle, wherever it is parked, does not depict the fact that it is parked at 591 Osborne Court, nor does it depict that there are other police officers that accompanied him per his direct testimony and per the SOP. So I would say,
so first,
does not properly depict what the officer has stated is the standard operating procedure, and therefore we do not know whether or not this is authentic.
Okay, so first part of your objection is that you said you didn't know they were going to bring the body cam video, but that is, you had the opportunity to do discovery in this case, did you not?
Yes.
Did you receive a copy of the video?
No, no, ma'am.
It was not included in the discovery?
No, ma'am.
Your Honor, there's a notation that the video is available upon request on the discovery notice that was sent on July 16th, 2025. It was emailed to Attorney Wright.
Please support. What I do have is a copy of the warrant, copy of the report, incident report.
Is there a transmittal sheet that tells you what you're getting and what's available?
No, ma'am.
Mr.
The discovery notice was filed with the clerk's office, and it states in the section that says other BWC, which is body worn camera.
All right, so first part of your objection is denied. The second part of your objection has to do with whether the cars are placed in front of the building.
No, ma'am. Whether or not the depiction of that particular footage properly represents what the officer has stated is standard operating procedures when anytime an officer of Clayton County is dispatched to an incident location where there has been the allegation of family violence, domestic family violence.
Okay.
The state would offer that's not the standard for admissibility for the evidence, Your Honor.
It is not. That objection is denied. Also, Exhibit 1 for the state will be admitted.
Permission to publish, Your Honor.
You may.
Attorney Tipton, if you would go to 1 minute, 18 seconds.
One minute, 18 seconds.
I'll tell you what, just start from the very beginning and we'll play through 1 minute, 18 seconds.
You thought we was playing with you? Well, thank you. You hear me? Hey, what's going on, Becky?
He's cocaine, alcohol. Yeah, he didn't come home last night. He doesn't live here, so I let him in, and he all irate and fussing, trying to argue, calling me all kind of bitches in front of my daughter. And I just want him gone. Okay. I just want him gone.
Hey, boss.
He don't work. He don't do nothing. He's just like a waste of space.
How you doing,
And then
boss?
he want to blame everybody else.
I ain't got no warrant. So how about this? Hold on.
I don't have no
You good, you good.
I
You
just
wanna step
came
out?
home.
I got you. Step outside and talk to me so we can keep y'all.
Yeah, let me
You can come to
I'm hungry right now. Yeah, my daughter. He throwing food in the floor, acting like he's being bad.
Baby girl just put me in my
Ain't
loop.
nobody tell you, ain't nobody touch you. You pushed your way into my house after I asked you to go back where you was at last night. You ain't not that nothing.
So what's going on there, boss?
You hear this bullshit, man?
Yeah, but what's happening? What's going on? Why we here?
Hey, listen, man. This what happened. Should be last night. She go, her family live in the I've been shot up over there. You know what I'm saying? I don't go over there with her.
I got you.
I don't hang out like that. You know what I'm saying? I'm not into the atmosphere. So I'll go to my mama's house. My uncle just died. My auntie just died. So I say, when she leave, I've been in the house for the longest. Coping and being depressed. So yesterday I say, shit, baby. If you going over there, let me drop you out for the loop. And I just go around my folks. Talk about the game or whatever going on today.
Yeah.
You know what I'm saying? Take me around me.
I got you.
Oh, no, nigga. I take you to your mama's house. I go to my mama's house. Everybody there in our family.
So he ain't go home.
Come back home. When I come here, notice she done took me keys and all this shit out. I can't get in the house. So I say, hey, baby, you right up the street. Baby, man, I'm in the house. She can see me on the ring over here. Baby, I'm in the house. Can you come just let me in the house? You go back to your folks' house, cause I don't hang out over there.
Just to verify, do you live here?
Yeah.
Okay.
All my stuff in there.
Okay.
But I'm like, shit, can you just let me in the house? You can go back the way you went. I'm just gonna, man, it was 7 o'clock. I'll show you my phone and everything. I'll show you the text message on text on.
7 in the morning?
No, 7 o'clock yesterday.
Okay.
So why she saying I didn't come home last night? What the fuck I'm gonna do? What you expect me to sit on the porch from 7 o'clock to goddamn 1, 2 o'clock in the morning?
So let me ask you.
That's my little sister.
So just checking, you said you came back 7 o'clock last night.
Man, I came back 7. My sister, she dropped me off.
And that's what you call asking for her to come and unlock the door for you?
Yeah, that's all.
Hey,
give us 1 second, man. That's all.
Okay, then.
Man, I ain't finna goddamn leave. I ain't got no gas in my car. Just being nasty for what?
So what ended up, why we here now? Like, what led up to this?
I came home. I didn't
So
come
from
home
7 o'clock,
like,
you left, and then you came back now.
Yeah, I had called one of my little better, man. Hey, bro, that shit embarrassing. What I'm gonna do, sit right here from 7 to 1 in the morning till she get finished done with her people to come pick me up. Come on, bro. That's not embarrassing to you.
I got you. I feel you.
And I can't get in the house.
So, do me a favor. What's your, you got an ID on you? Driver license?
I don't have no ID.
Oh, good. What's your name?
Yeah, I do have, what's the name, man? You see this?
Is it on you?
It's in the house.
No worries. What's your first name?
My name is Cordero Clayton.
Spell it for me, please.
Cordero.
1141, Fort Jonesville, copy it. Signal 29, Pierre Boulevard, Battle Creek. Pierre Boulevard.
You didn't me spell that for me again?
You want my ID? I just give it to you.
Nah, because I don't want y'all crossing paths. I just want you to talk to me.
Man, I ain't got nothing to
You
do
good?
with her.
I ain't, yeah,
She
you
can get it. All my
right?
information, my birth certificate, everything, you know.
I got you. Just spell your first for me.
Cordero.
And your last name? You say Clayton?
All my stuff right here, man. My birth certificate is.
You good? What's your last name?
Cordero Clayton. Clayton. And we done been through this, man.
What's your date of birth?
Listen, man. I really don't. Giving you my information, bro. What you doing? A free warrant check?
No, actually, everything's gonna be everything's wrapped up because you have to do a report after this. I'm just putting your name on the report.
She done called the police before. The girl keep luring me into this dumbass situation, man.
You say what's your date of birth?
Handling me any kind of goddamn way.
Well, check me out.
I done goddamn did everything for this girl, man. Keep handling me, goddamn, yeah. I keep coming back to this shit. Bro, I ain't never put my hands on this girl. This girl just butt me in my goddamn mouth.
Shouldn't have hitting you. Let me see.
Man, come on.
If you stop video.
Man, no, man.
Officer McGriff,
Yes, sir.
of what you just watched of this video, did you make any assessments as to whether or not charges were viable at this point?
At this point, yes.
Okay. And what was your assessment at this point? Potential.
Criminal correction, battery, family violence. But I knew I had battery. I couldn't clarify it was family violence just as of yet because I didn't get to ask him how long they either lived together or they've ever been married.
Okay. Now, as the video will continue, did you have an opportunity to also speak to Ms. Goodman?
Yes.
Okay. And based on the totality of your investigation, both speaking to both Mr. Clayton and Ms. Goodman, did you make a determination that you pursue charges ultimately?
Yes.
And did you in fact do that?
Yes.
And is that the basis of the charges that we are now here in the court before today?
Yes.
No additional questions at this time, Your Honor.
Ms. Wright?
Your Honor, I'd like to call the alleged victim. I have no further from Ms. McGriff.
All right, no further questions. May Officer McGriff be excused?
We would ask that he be held in the event we need to rebut.
All right, Officer McGriff, that just means turn your video and your microphone off. And should we need to have you for rebuttal, we'll bring you back. All right, we'll call him Mr. Cordero Clayton, is that correct?
Yes, Your Honor, he's present and before the court.
All right, let's take down the video. You can stop share screen.
Yes, Your Honor.
All right, so Mr. Brooks, I'm gonna put Officer McGriff in a breakout room until such time as we need his testimony.
Yes, ma'am.
Officer McGriff's gonna be in breakout room number 3. Officer McGriff, if you would just go into breakout room number 3, we'll come get you when we need you. All right, Mr. Cordero Clayton.
Your Honor, I would like to swear in the witness.
Okay, Ms. Wright, for technical reasons, you're gonna have to move over to your right and allow Mr. Clayton to be in the video frame, okay? All right, thank you. Mr. Clayton, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yeah, ma'am.
All right, you can put your hand down. Ms. Wright, your witness.
Mr. Clayton, why are you here today?
I have no reason. I mean, I don't know. Me and the young lady, we don't have nothing. We don't talk. We don't communicate. The past is the past.
Did you write a statement on?
No, ma'am. I didn't write no statement. I wrote a statement saying that the accusations was not true.
Okay.
I don't live at her address. I don't have any mail there. I mean, that's the statement that I wrote, and I got it notarized.
Yes.
Did you? Affidavit.
Yes. So did you also state in that statement that you were not injured by Ms. Goodman?
Yes, ma'am.
And is that your testimony today?
Yes, ma'am.
Do you seek today to have the charges that have been brought against Ms. Tanisha Goodman dismissed because you were not injured?
Yes, ma'am.
Mr. Brooks?
Mr. Clayton, you had the opportunity to observe the video that was just played. Is that correct?
Yes, sir.
And you observed yourself in that video, correct?
Yes, sir.
You recognize your voice in the video?
Yes, sir.
And in the video, you also heard yourself say that you live at that address and that she busted you in the lip. That's what you said, correct?
Well, he asked me.
That's not my question, correct?
Yes, sir.
Okay. You said that.
Yes, sir.
Okay. No additional questions.
I have additional questions. At the time that you were being interviewed by the police officer on the incident date, were you under the influence of any alcohol or drugs?
Yes, I was. Yes, ma'am.
You were?
Yes, ma'am.
Did you have any idea of what you were stating to the police officer at that time?
No, ma'am.
Did you subsequently write the statement that I am referring to that is called an affidavit and then have it notarized and take it to Clayton County State Court and have it stamped in?
Yes, ma'am.
And is what you put in your affidavit the accurate depiction of what really happened at the house of 591 Osborne Court between you and Mr. Tanisha Goodman?
Yes, ma'am.
is your testimony today that as of the date of you writing that affidavit that has been submitted into evidence, well, I'll move the court. Let me go ahead and discuss it. So let me lay the foundation on it so I can get it into evidence, Judge. Since we're here. Let me show, it's in the court's file, so I asked the court to allow me to show the statement to the witness at this time.
You may.
Yeah, I'm sorry, I don't have a copy of the
I
statement.
guess.
Yes, it was, I'm sorry, Judge, it was stamped in on, I think, the 16th of February, 2024. There's a stamped copy. I got it out of the clerk's file.
So, Ms. Wright, just from a legal standpoint, is it your understanding that the primary victim in a domestic violence case just needs to recant the information that led to probable cause for the cessation of the prosecution of the case?
That's not my understanding of the law, Your Honor. My understanding of the law is that if in fact there is a crime that has been committed, then yes, the state does have the right to move forward. However, we have just deduced from evidence, direct testimony from the alleged victim, that at the time that he spoke with the police officer, he was inebriated and or under the influence of drugs.
Well, but the video shows that he indicated that she bust him in the mouth. So at the time that the video, that contemporaneous with the investigation of the case, the officer had, based on the video that you played, probable cause to further investigate and make an arrest for domestic violence. All of the elements were there. He stated that he lived there. He stated it several times. He said that he had forgotten his keys, that he didn't want to go hang out with her family because he doesn't really vibe with them like that, but that he asked her to go to her family, and then he wanted to go hang out with his people. But then when he didn't come back home, she said, well, he stayed out all night. So even from the standpoint of the person who is the defendant in this case, she said he stayed out all night, which would indicate that she has an expectation that he would be back in the house. And so there's collaboration there between both parties based on what is in the video, that he resided in that place, or at least was expected to be in that place. He then stated that she bust him in the mouth because they had a disagreement about him not hanging out with her family. I don't vibe with them like that. So that suggests a relationship that goes beyond a one-night stand or him just showing up at her house. So now that he's come and he, as we have seen in other domestic violence cases, the alleged victim is remorseful or does not wish to go further with the prosecution, which is a classic sign of a domestic violence. The victim often does not wish to prosecute despite the fact that there being sufficient probable cause and evidence of domestic violence. So now you've come and want to present to the court. I'll take judicial notice of it. If you said he stated it, he stated it, he filed it into the court that he doesn't wish to prosecute and nothing happened, that's fine. But I do want to let Mr. Clayton know that he there's a risk of perjury because you made a statement before a police officer. Now you're denying that statement under oath, saying nothing happened, but there's a contemporaneous video with the situation that occurred that caused the police officer to investigate. So I just want to let you know. Sure.
You want me to respond? Hold on. As I stated previously, I have not had an opportunity to review this clip.
All right, but not for lack of notice.
I'd like to finish. And my reason for stating this and having to stand firm on this is because this court, according to what has just transpired today, we have seen snippets. Those snippets have, in my opinion, been advantageous for the state.
You want to play the rest of the video?
Have the opportunity to see the entirety of that video. And
play the video.
According to what I'm being told by the victim, the so-called victim.
Play the video.
Yes, those snippets were.
Let's play the whole video. Ladies and gentlemen, for the 11 o'clock calendar, please thank you for your patience. We're going to finish up this hearing, and then I'll call the calendar. If there are cases where the motion has been withdrawn, go ahead and let Mr. Tipton, it's in a chat to Mr. Tipton that the motion has been withdrawn so that we can move quickly through the calendar. Thank you. All right, Mr. Tipton, hit play.
And Your Honor, just so the court is aware, Mr. Bixon and I did come to an agreement. We are going to do a consent to that, to a motion that's based off of our negotiations. It's a little different from the initial motion. And Mr. Bixon be excused?
Sure, Mr. Bixon or Mr.
Yeah.
Tipton, whenever y'all present the consent, I'll go ahead and look at it.
Thank you, Judge.
All right.
Thank you. Your Honor, I'm going to start over from the very beginning because we initially cut out the first minute.
Okay,
But
go ahead.
I hate to interject, but I have to put this on the record. Your Honor, seemingly that counsel for the defense has never seen this video. And for me to observe it on the actual day of the hearing being heard, I would respectfully ask this honorable court to not just play it all the way through in its entirety now, but allow me the opportunity to review it, go over it with my client so that I can have the fair and proper opportunity to raise the proper questions to the defense.
Ms. Wright,
Yes.
based on the solicitor's office has not changed their policy even since before the previous solicitor. We had that discussion this morning. What they do is they require you to come in and sign for the video. They will give you notice that a video exists. If a video exists, when they send you the discovery, then they will give you notice of that. And then you have the opportunity to come in and either waive the video and have it sent to you, or you can come in and review it. If you did not do that, ma'am, that is not the court's issue. You're standing firm on a motion that you filed in quite some time ago. This is the second time it's been on the calendar because you had a conflict, and so that's allowed. That's not a problem. But we're here for the second time, and not once did you think you're talking about an officer who responds to a call in Clayton County all day, every day for the last at least 5 years, at least since I've been a magistrate. That's been 9 years ago. Clayton County has had video, body cam. So if it is an anomaly if body cam does not exist. Generally, the general thought is body cam exists if an arrest has been made or if an investigation, especially of DUI or domestic violence. And so your failure to go and get the body cam video is not the court's responsibility.
I agree wholeheartedly. That's not my contention though, however, Judge.
So now you want to we're in the middle of a hearing you insisted on having, and
Yes,
now
ma'am.
because a video that you were given notice of is
I was not.
available,
That's
you
what I'm
just
saying.
said, I don't want to see snippets. Now I want to see the whole video. So the court is accommodating you. Let's play the whole video. Now, so let me just tell you, Ms. Wright, you can appeal me if you want to, but your motion to dismiss is denied.
Okay, Your Honor, my position is so we can get it
Your
on the
motion to
record.
dismiss is denied.
I agree. Can I just perfect the record, Your Honor?
You can
My-
perfect whatever you want,
Yes,
ma'am.
ma'am. All I want to say is that everything that the state has given me is in my hand, and that I never got notice that there was a video. I would not have compromised my client's freedom without coming into the court looking at the video if it was available. I'd have everything that was emailed to me, and there was no cover sheet indicating that there was a video. I found out about the video during my due course of examining the officer this morning. So if you want to dismiss it, that's fine. But I have to get that on the
Now,
record.
there's probable cause. The officer did what he was supposed to do. The gentleman made a statement that he was hit. So until such time as it comes before a court for trial, the officer didn't make a mistake, and the state had the right to accuse based on what I saw. Now, if you want to go through the rest of the video, I have given you that opportunity, but you don't want to do that on the record. That's fine. I don't have a problem. But what I do ask is that you review the video prior to trial, because this case is coming up on a trial calendar.
Your Honor,
Has the date been set for the trial calendar? Your Honor?
Ms. Val, is this on Monday's calendar?
I have a notice here that something about October. It was a calendar call.
October 6th is the
I think it's October 6th. Your Honor, I believe we attempted to serve Mr. Clayton for that date. I think October the 6th. And it's my understanding that he has received notice of the date of trial and is expected to be here on October the 6th. Miss Hemphill was in the room, and I think Investigator Incurre perfected service for that date. I think.
All right, so Mr. Clayton, October 6th is the trial date. If you have been served with a subpoena to appear at trial, I can't control what you say. That's between you and your attorney, but I can control whether you are here. And if you fail to show up for trial, I can send county Uber to give you a ride.
Your Honor, your victim has informed me on.
Okay,
more
Ms. Wright, let's be clear. I don't have a victim. I'm neutral in all of this. I don't have a victim. I don't have a defendant. All I know is if Mr. Clayton doesn't show up for a trial and he's under subpoena, I can send Clayton County deputies to go get him. That's all.
Yes, Your Honor. The state's victim would, I'm asking for my client, but the state's victim is telling me that he wants a copy of the video. I would like to know right now, Judge, can I obtain a copy of this video right now?
Okay, it's not my video. I don't have possession of it. You know the rules for the the solicitor's office. Follow those rules and get the video. That's all. I don't control that.
Thank you, Your Honor. There being nothing further, maybe be.
They both
Yes,
can
ma'am.
come to the solicitor's office and we can take care of both matters.
Yes, ma'am. Thank you.
Judge, I just wanted to confirm, this defendant, Goodman, is scheduled for the October 20th calendar call.
I'm sorry, Goodman is on the October 20th calendar call?
Yes, ma'am.
All right, so y'all got a little bit more time.
Thank you, Your Honor.
All right, thank you, Ms. Wright. All right, Mr. Tipton, you can take the video down, stop screen share.
Yes, Your Honor.
All right, ladies and gentlemen, the 11 o'clock calendar. Let me go, so Kimberly, the motion to dismiss is denied. I'm sorry, on Kennerly, the motion is granted. That was the plea and bar. On Goodman, the motion to dismiss is denied. Clayton.
I'm sorry, Judge, did you say Satan?
Yes.
Yes, Judge. So we spoke with Solicitor and I at a pre-conference. I think I do have an issue with the notice with the officer appearing over Zoom. So I looked back in the clerk's record on the online docket. Our office never received a notice for this court date. I just wrote it down after our last court date. But I think even if we did receive it and it was a hybrid notice, we still require notice in the intent from the solicitor's office with 30 days notice from the solicitor's office if they have a witness that is testifying over Zoom. We never received notice.
Okay, let me ask you this before I waste time on the court's calendar. Is this motion going forward? Because if it is, we can do it prior to trial.
It would be going forward.
Everybody will be in court.
Yes, Judge.
All right, so we're going to move the motion to prior to trial.
Understood,
Anything
Judge.
else? All right.
And Your Honor, what trial date is this set for?
What trial date is Clayton on, Val?
It's going to be noticed, Judge. I have to look at it.
All right.
Reset further notice for trial?
Yes.
Understood, Judge. Thank you. With that, may we be excused?
You may. All right, the 11 o'clock calendar. Thank you all for your patience. Let me go ahead and call that calendar. All right, first case on the calendar is Najee Isaiah Clark. That's Mr. Holt Dennis.
Good afternoon, Your Honor. That motion is going to be withdrawn, and he will be appearing on Monday for trial. We're going to try to get that worked out, but we're withdrawing the motion to suppress at this time.
All right, Clark is withdrawn. Next is Desiree Marie K. Franks.
Good morning again, Your Honor. Angie Walton for Desiree Franks. I will be filing the withdrawal of those motions and just confirm. I don't think we've been noticed for Monday, but I just want to be sure.
What calendar is Ms. Franks on, Ms. Val?
Stand by, Judge. Let me just say.
Okay. Hold on a second, Ms. Walton. Next case is.
Your Honor, I think the calendar reflects October the 6th at 10 a.m.
Okay, so you're on the October 6th calendar, Ms. Frank, for Ms. Franks.
All right. Thank you so much, Judge.
Thank you. Fuller. Mr. Barton has a conflict, and I think he announced that a while ago. So for Fuller, that's an attorney conflict.
You want to reset that to the next motion calendar, Judge?
Yes, please.
That's December 11th, 11 a.m.
Okay. Thank you, Ms. Val. All right, Jeffrey Scott Keith, James Sullivan.
Jeffrey Scott Keith. Mr. Keith is here. I'm not sure about the attorney.
Okay, so I see a conflict for Mr. Sutherland for today.
Yes, Your Honor. He just reached out to me a little earlier saying that he was in another court ahead of this. I'm not sure what the nature of the other conflict is, and I'm not sure if he'll be here before the calendar's over.
Okay. Yeah, I'm not sure what Barton's was either, because I think he said, I don't know if he was at trial somewhere else.
So, Your Honor, if you recall, Mr. Barton did have a conflict, and then we also had an issue with a training conflict.
Right. So that one we moved. Yeah, that one was to be moved anyway. But yeah, we'll hold for Sullivan for a little bit until somebody tells me what the conflict is. Where is he going before he comes to me?
Yes, Your Honor. I'm going to see if I can find that.
All right, thank you. That case is closed. We did that yesterday. Amaya Kamora Neely Lloyd. I have a conflict for Mr. Moody for the week of the 17th.
Yes, Your Honor. I've been speaking with Mr. Law, who has inherited all of Mr. Moody's cases because Mr. Moody was appointed to the bench in Henry County.
That's right.
James Bowles. James Bowles was appointed to the bench, not to.
Oh, I'm sorry.
No, yeah, James Bowles.
Oh, I got that mixed up. I spoke with Mr. Law about it though, and he was unsure if they'd be able to make it in time. They both had things. One attorney is going to Savannah, and one's going to Upson County.
Oh, yeah. All right, so we'll move that to prior to trial, or move it to the next motions calendar.
December 11th, Judge, at 11 a.m.
Okay, so that's Lloyd. All right, Wali Basil Nureddin.
Good afternoon. Good morning still. Afternoon now. Good afternoon, Your Honor. Attorney Jonathan Reed. I believe Mr. Wali is present on the Zoom as well. We're withdrawing those motions, Your Honor. We received discovery late last week.
All right. So did you have any need to speak with the state to pre-try?
I would like to pre-try, but I've reached out via email. So if
okay, good.
Email is sufficient, Your Honor. Yes, we'll continue those negotiations via email and hopefully be placed on the next calendar.
Ms. Val, is Nureddin already on a calendar?
Be noticed, Judge.
Okay, so you'll get notice of that. David Oliver.
Judge, that's my client. He's present here in the courtroom. We actually do have a negotiated plea if the court would entertain that. I believe we're ready.
The court will. Mr. Let me just call the last cases on the calendar and we'll do Mr. Oliver's plea. Next is Jesse Ray Ripton. That case is closed.
Your Honor, that's a motion for an interlock waiver. I reviewed his motion, and his motion specifically states that he does have a financial burden that makes it impossible for him to pay for the interlock waiver. So I would defer to the court.
So you all don't object to it?
State defers to the court, Your Honor.
Okay. Mr. Ripton, is Mr. Ripton in court or on video?
Mr. Ripton in the courtroom? I don't see a Mr. Ripton in the courtroom, but I'm not sure if he's on the Zoom.
Okay, the court will review the motion for the hardship. All right, next is Sarant, Jaleesa Sarant Franklin.
Yes, Judge.
Good morning, Judge. I'm here.
That's my client, Judge. We are going to withdraw the motion to suppress that's pending. And she'll appear on Monday. If she wants to stay on and have some further discussions about, but I would just say that we're withdrawing the motion at this point.
All right, so Ms. Sarant Franklin, you'll be here in court on at 9:30 on Monday in the court in person at 9151 Terra Boulevard on the 3rd floor, courtroom 304. You want to make sure you get here fairly early because the lines on Mondays are ridiculous.
Okay.
All right, thank you. We'll see you on Monday.
Your Honor, before she signs off, I just want to confirm that a new recommendation was offered.
Yes, Judge. Sorry, Mr. Brooks. I have made that offer to her, and perhaps if Mr. Tipton, before I speak out of turn, my understanding is that the offer is going to stay open until Monday. If that's not your understanding, please let me know. But I believe that that's where we left it, unless I misinterpreted something that I was.
That was my communication. Was if there was no motion going forward, the offer would stay open until Monday.
Can I speak with my attorney, please?
Absolutely.
All right, Ms. Sarant, it's better if you hold on and let me put you in a breakout room. So just hold on for a second.
We'll talk on the phone at the appropriate time.
Yeah, on the phone. Okay.
But if you stay on the call, just stay on the call and mute your mic. And then when we get through the calendar, I'm going to give you a call and explain everything that's going on right now. If it's not.
All right. Okay. The next case is Shumpert. Eric Shumpert.
Judge, I believe that is Attorney Tortorello's case, but I do believe that is a withdrawal. In fact, I can confirm it on our communications.
And he'll be in court on Monday?
That's my understanding, Judge.
All right. And the last case on the calendar is Veal, Rolanda Veal.
Yes, Judge. Miss Veal is on the Zoom call. And Miss Veal, we are withdrawing the motion. I believe we're going to resolve the case with the plea, but I think, no, that's not, but I believe we're going to resolve it. But at this point, we're just going to have her come in on Monday just to make sure that that is still the case.
All right. So the Keith case, let's go ahead and move that to either before trial or let's move it to the 12/11 calendar.
I'm sorry, what was your last name? Keith. Mr. Keith had just indicated that his attorney indicated he would be here at 1. I understand that you just said it was going to be moved.
He said he'd be here at 1.
He's indicating yes.
We don't have a 1 o'clock.
Yeah, no. Yeah, so we're going to move that to the December 11th calendar. So he can tell his attorney that. December 11th at 11 a.m.
December 11th at 11.
All right. So we have Clark has been withdrawn, Frank's withdrawn, Fuller, there's a conflict and we're moving it to December 11th. Keith will be moved to December 11th. Letsum is closed. Lloyd is December 11th. Nuruddin is withdrawn and they're going to continue to talk. Oliver is going to be a plea. Ripton.
I think you said you were going to review that.
Yeah, I'm going to review the motion for the hardship. And Sarant Franklin is withdrawn. Shumpert is withdrawn. And Veal is withdrawn. So Oliver, come forward.
And Your Honor, since we're moving the Keith motion, may we excuse all of our witnesses because I believe that means we won't have any witnesses we need to present.
Yes. Based on the recommendations from the solicitor's office, any case that I've mentioned so far where they feel that they need to excuse anyone, that's fine with me. Okay. All right, Mr. Oliver, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, I think.
All right, you can put your hand out. You're before the court on State of Georgia versus David Oliver, 2022 CR 01453. You're before the court on DUI less safe count 1 and DUI per se count 2. You're with your attorney, Mr. Owen Lynch. Mr. Lynch, what does your client plead to the offenses before the court?
Judge, it's going to be a plea of guilty to count 2, I believe would be the DUI per se.
All right.
That is correct, Your Honor.
By entering a plea of guilty to count 2, count 1 will merge. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. You understand all of these things?
I do.
All right, factual basis and recommendation, please.
Yes, Your Honor. On February 4th of 2022, officers with the Clayton County Police Department observed a vehicle being that was on and running at the intersection of West Fayetteville Road and Bethsaida Road in Riverdale, Georgia, in a portion of Clayton County, in a portion of Riverdale that's within Clayton County. They observed the driver behind the wheel being asleep. They knocked on the door and awoke the driver. Once the driver was awoken, they could smell the odor of alcohol coming from the defendant's breath. The defendant, Mr. Oliver, did admit to consuming an alcoholic beverage. He said that he drank 2 12-ounce natural ice beers a couple of hours before driving. At that point, they initiated standardized field sobriety tests, which he consented to. During HGN, the defendant did not participate. He just stared forward. After giving instructions an additional time, he participated and they observed 6 out of 6 clues. He then performed the walk and turn, which presented 5 out of 8 clues. And then he completed the one leg stand, presenting 2 out of 4 clues. At that point, he was placed under arrest. Implied consent was read. A blood search warrant was applied for and given. The blood was properly drawn and tested at the GBI, giving a BAC of 0.169. Those are the facts of the case, Your Honor. State's recommendation for count 2 DUI per se is 12 months to serve 24 hours. I'm sorry, to serve 2 days credit for time served because he spent 2 days in jail. Balance probated, a $300 fine. Substance abuse evaluation, any recommended treatment, no drugs or alcohol, subject to random testing. DUI risk reduction course, 40 hours of community service. This is Mr. Oliver's first in life DUI. Nothing further from the state.
Just briefly, this is his first in life DUI. I have explained an affidavit of first conviction and limited permit, but just more importantly, Judge, my client has not had any issues with the law. Since this time, we are asking the court to accept the recommendation from the state. I think he's remorseful. He has already completed the risk reduction course, and he understands the terms. I've explained it. No alcohol while on probation, and so we're just asking the court to accept the plea as negotiated.
All right. So, Mr. Oliver, for somebody who has a first DUI, I always hope that it makes enough of an impression upon you that you don't have a subsequent DUI. I want to remind you that we have options. You can stay home. You can get Lyft, Uber, any of those rideshare things. I'm not advertising for them, but they serve a purpose in the context of what we're talking about. You do not have to put your life or anybody else's life in jeopardy. because that's a choice. That is a solid choice that you make. So, sir, I'm going to accept your plea of guilty. I'll sentence on count 2, count 1 will merge. I'll sentence you to 12 months to serve 2 days credit for time served. Balance will be probated for you to do a substance abuse evaluation, any treatment that they might order. $300 fine, which is going to be closer to probably $700 because of the surcharges on a DUI. You're to have no alcohol or illicit drugs during the course of your 12 months probation. You're subject to random screens for alcohol and drugs. Don't, have somebody tell you, well, they're not going to catch it, or, every day, every Tuesday. I have several people on my calendar who random screens catch it. So please don't risk the next 12 months. Don't risk coming back to jail for something that you should be able to avoid. You've done the risk reduction course, present the paperwork from that to probation. Once you meet with your probation officer, and you're to do 40 hours of community service. At this time of year, as we're getting into the colder months and as we're getting into the holidays, there's plenty of opportunities to be of service to other people and to the community. So please take advantage of the opportunity to do that. All right. When you leave the courtroom, you're going to go, is she in courtroom 305 or 303?
I'm not sure if you're asking me, Judge.
I think 305. So when you leave the courtroom, you're going to go to your right into the next courtroom. And when you go into that first set of double doors, there should be an office on one side or the other. Miss James, who is our probation expert, she's going to do your intake. She's going to explain to you exactly what you need to do to be successful on probation. Please remember, the quickest way to get rearrested is to not appear for your probation reports. You have got to report as long as you're on probation. Our probation officers here are amazing because they are here to help you successfully complete your probation. Okay. So if there's anything that you're having difficulty with, please make sure you tell them so that they can help you figure it out. Right? Yes, ma'am. All right. Thank you, sir. You're free to go at this time. Just make sure you check in with probation. All right. So unless there's something I'm not aware of, I think that concludes our calendar.
Judge,
I believe that Ms. Sarant wanted to speak to Mr. Lynch.
If I can speak to Ms. Sarant, it's potential, it may, if you could just.
All right, y'all go ahead and talk. I'll be back. Just let me know.
Judge, excuse
Yes,
me.
no problem.
I missed whatever happened with Mr. Maddox from the 10 a.m.
Okay, I'll go. Wait a minute. You know what? I might have missed that too. I don't have anything written down. Hold on. Let me go back and jog my memory. Does anybody know what we did on Maddox?
Yes, ma'am. Mr. Maddox, this was the one where they are a SAG, and so
yeah. So Mr. Maddox has not appeared. We're going to go ahead and move that to, Mr. Maddox's attorney, Mr. Overman. He did present a conflict. We're going to move that to
is it December 11th?
December 11th calendar. And Mr. Maddox is free to go at this time.
Will
so
that
we'll
be
move
10
that to
a.m.?
Yeah, we'll move it to the 10 a.m.
Okay, thank you.
You're welcome.
You said
Thank
10,
you.
10 a.m.? All right.
Yes.
All right. Thank you. I believe that completes both the 10 and 11 o'clock calendar. Is that correct, Your Honor?
Yes.
It's the state excuse, Your Honor?
Yes. Thank you. Wait, no. You mean you, the state, not both of y'all. Okay, yeah, you're excused, Mr. Brooks.
Whichever you need. If you
long
need.
Long as you leave me Tipton, because if Mr. Lynch's client wants to take a plea, I want to be able to take the plea.
I understand. Thank you.
All right. Thank you.
Gotcha. Thank you. And all officers are excused. We do not need any other officers. I saw some messages. You guys are all free to go. We're just wrapping up with a couple last minute negotiations.
just real quick, I know this is maybe a little risky, but, would you consider sending the, if she gets the eval done and then successfully does like a certain number of drug tests? All right, but you don't have any support. Mr. Tipton, if you could check your text and give me an affirmation there. I think we're ready to go forward if that is not an objection.
After we get the benefit of it. That is Miss Vio, correct?
No, this is Ms. Sarant.
Miss Sarant, I'm sorry, Miss Sarant. Yeah, that works.
Okay. Your Honor, we are ready to go forward with a negotiated plea for Ms. Sarant.
All righty.
If I can just get. Here we go. We're ready, Judge.
All right, I just trying to find the calendar that's on. All right, Mr. Franklin, raise your right hand for me.
Unmute yourself, Miss. There you go.
Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
Okay, you can put your hand down. You're before the court on 2022 CR 01454, Julisha Sarant Franklin for speeding 16 to 20 miles per hour over the limit, count 1, DUI less safe, count 2, marijuana 1 ounce or less, count 3. What does your client plead to the offenses before the court, Mr. Lynch?
Judge, count 1 will be a no-low plea. Count 2 will be null pros pursuant to the agreement, and count 3 will be null pros pursuant to the agreement.
All right, by entering a plea of no low to count 1, counts 2 and 3 will be null pros. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, Judge.
Action basis recommendation, please.
Yes, Your Honor. Your Honor, on December 16th of 2021, officers with the Clayton County Police Department observed, observed a vehicle driven by the defendant, to wit, a black Impala, traveling at 48 miles per hour in a 35 mile per hour zone. Upon starting a stop of the vehicle, they determined that the defendant before you, Ms. Franklin, had marijuana in the door of her vehicle. They performed several DUI standardized field sobriety tests that yielded clues. After review of the file, Your Honor, we've noticed some issues with the file and are only going forward on the speeding. For the speeding, it will be 12 months probation, suspended fine of $100. No drugs or alcohol, subject to random testing, substance abuse evaluation, and any recommended treatment. Those are nothing further from the state.
Mr. Lynch?
So, Judge, that is the offer that we have accepted. I did want to ask the court to consider some things on Ms. Sarant's behalf. Ms. Sarant she's not being convicted of a DUI, and won't get into the issue, what led to that, but she hasn't had any issues since. She did let me know she does do work in the community as far as like community service, but she is not currently employed. And so what I was going to ask the court to consider is that since she's going to be subject to random tests for drugs and alcohol, and that also she's going to have to complete a substance abuse evaluation. If there's no recommended treatment, or if that is complete, and if she has submitted multiple tests which are negative for alcohol and illicit drugs, would Your Honor consider either suspending or allowing her to go on non-reporting at that point? Speaking to Ms. Sarant, she's no longer consuming substances. Alcohol, certainly she understands that will be banned, and she's not consuming any substances. So we're just asking if she can complete the evaluation and submit multiple subsequent clean tests that Your Honor would consider suspending at that point. And also if you would consider waiving the probation fees in this case.
Mr. Tipton?
Your Honor, state would object to agreeing to this on the front end, but if after several successful several successful tests and completion of all the conditions of the substance abuse evaluation, the defense wished to petition the court at that time, I believe that it'd be more appropriate to address the issues at that point.
All right, the court will allow probation to submit a request for non-reporting after 4 clean tests for substances, and after Ms. Sarant Franklin has completed the substance abuse evaluation and no treatment is ordered.
Thank you, Your Honor.
All right, thank you.
Does Ms. Sarant need to?
Yeah, Ms. James, I'm gonna put you and Ms. Sarant, I'm gonna put you and Ms. James in the breakout room. She's gonna do your intake for probation. Once she has completed that, then you don't have to come back to the main room. You can go ahead and get started on whatever it is you need to do for probation. Please remember that missing your probation reports is the quickest way to get rearrested. Also, I think it's room 5. Also remember that if you have any difficulties with completing anything, you need to address it with your probation officers, okay? All right, I'm gonna
Yes,
put
Judge.
Miss James in breakout room number 5. I'm gonna put Miss Sarant in breakout room number 5. And then once they come back, then we'll be in a we'll adjourn.
Your Honor, may the state be excused.
The state may.
Thank you, Your Honor.
All right.
Your Honor, did you say anything about waiving probation fees?
I did not.
Okay.
Thank you.
Judge, I believe that concludes my business as well. May I be excused?
Not until your client comes out of the breakout room.
Fair enough.
Your Honor, I'm done.
Thank you, Ms. James. Thank you, everybody. Thank you, everybody. Court is adjourned.
Wait, Judge, I have some questions for you, just
Yes,
for you.
ma'am. Oh, okay.
Everybody else can go.
All right.
Um,
Hold on a second.
It's not personal.
No, I just wanted to stop the recording.